What a day, guys. Take a look at what I just found for you guys. The Ripple and SEC legal battle is over. Ripple, a blockchain corporation, and the United States Securities and Exchange Commission are engaged in a high-stakes court dispute over the regulatory status of the XRP cryptocurrency. This battle is still ongoing. A notable Ripple analyst by the name of Jack the Rippler, who posted the information with his 200,000 followers on Twitter, stated that there are other important dates that are still to come that could determine the fate of this lawsuit. The following are the upcoming significant dates in the SEC v. Ripple case. The Securities and Exchange Commission, the SEC, has until March 13, 2024 to submit its remedy-related brief. Ripple has until the 12th of April, 2024 to submit its filing of resistance to the SEC remedy-related brief for consideration. Jack the Rippler tweeted that the deadline for the Securities and Exchange Commission to file its response to the Ripple opposition brief is April 19, 2024. In the event that it is determined that Ripple and its executives Brad Garlinghouse and Chris Larson have broken securities laws by selling XRP, Judge Analisa Torres will make a decision regarding the fines that will be imposed on them after these files have been submitted. At some point during the summer of 2024, a decision about the case could be made. From the time this article was published, the price of XRP, which is the sixth largest cryptocurrency by market capitalization, has been bouncing between $0.5 and $0.6 for several months. In the end, the decision will most certainly have a big impact on the price of XRP as well as its future. Investors in cryptocurrencies are keeping a close eye on the situation in order to anticipate the next possible steps. Meme coins have the power to transform hundreds of thousands into millions of dollars. Imagine, but on a far larger scale. What is the secret? Getting a head start, particularly during the I do period of preparation. Register for Nugget Rush right away. This cutting-edge meme coin combines the concept of play-to-earn games with the mining of gold in the real world. Enroll as soon as possible to take advantage of the current rates of the ICO. Display additional plus following the conclusion of the lawsuit. Both Ripple and the SEC have the ability to file an appeal against any findings that they do not agree with. In the event that a settlement is not reached at some point in time, this legal drama may continue to play out over the course of the next few years. When it comes to remedies and punishments, the dates that are most crucial to keep an eye on are March 13, April 12, and April 19. These are the dates when the two sides will present their arguments to Judge Torres. There will be a great deal of attention paid by the cryptocurrency community. Paul Grewal, Chief Legal Officer of Coinbase, and John, a prominent pro-crypto lawyer defending XRP holders, engaged in a conversation that provided light on a vital component of the legal environment surrounding Ripple's continuing dispute with the SEC. The conversation took place in a recent social media exchange. The relevance of the case that was heard by the Second Circuit Court of Appeals in 1994, Riva Sexy Realty, was the primary topic of discussion amongst them. Grewal, who expressed his respect for the case, brought attention to a particularly noteworthy aspect that emphasized the absurdity of defining an investment contract via the lens of ecosystem access. As a result, Grewal reinforced the position that the court takes regarding the Howey test, adding that the simple connection between investor fortunes and promoter activities does not easily satisfy the criteria. In order for the investments to be considered fortuitous as a whole, the court emphasized that a joint venture must be fundamentally dependent on the expertise of the promoter. In every instance in which someone brought up the decision made by the district court, my response was always the same. Read the Revit case from the Second Circuit. It was the First Circuit Court of Appeals in the SG case that decided the Elbry case. The cases involving Ripple and Coinbase are under the jurisdiction of January 2024. In agreement with Grewal's point of view, John Deaton noted parallels between the Revac case and the legal disputes that have been going on between Elbry, Ripple, and Coinbase. In particular, he brought attention to the jurisdictional subtleties, pointing out that the Revac decision, which is ruled by the Second Circuit, is relevant to the Ripple and Coinbase cases. Since the most recent, both Ripple Labs and Coinbase, two important cryptocurrency startups, are now engaged in continuing legal disputes with the Securities and Exchange Commission. These conflicts have enormous consequences for the future of the digital asset market. A federal judge made a decision on January 18 that allowed the Securities and Exchange Commission SEC to move forward with its lawsuit against Coinbase. However, the judge further limited the scope of the complaint by eliminating a number of the claims that were made by the SEC from consideration. due to the fact that it reduces the possible legal obligations that the company is expected to incur. This ruling was regarded as a temporary success for Coinbase. Regarding Ripple, the Securities and Exchange Commission, SEC, has just submitted a motion to have Ripple produce further internal records that are associated with the selling of XRP. It appears that the Securities and Exchange Commission is continuing to prosecute its case against Ripple in a vigorous manner. The price of XRP had a decline of 0.19 over the course of the weekend, and it finished the day at 5,308 cents, which was in contrast to the general rising trend that was observed in the cryptocurrency market. The ongoing CV Ripple lawsuit and the CC's plan to appeal the programmatic sales ruling undoubtedly had an impact on the prevailing sentiment among investors. There is no doubt about this. Therefore, after gaining 3.54 on Friday, XRP lost some of its gains on Saturday and closed the day at 5,308 cents, which was different from the rest of the market, which gained 0.63 to reach $15.79 billion. XRP's price was 5,308 cents, which was the lowest it had been since Friday. A recap of the SEC v. Ripple case: Ripple's request to file a reply letter that demonstrates the SEC was incorrect was granted by Judge Annalisa Torres, according to current court files and schedules. There were no significant events that occurred on Saturday. As a result of the complaint, the SEC requested that Ripple provide financial information and contracts that were made. The conclusion of the discovery phase concerning remedies is on February 12th. A significant decision was given by Judge Torres in July, which stated that XRP does not qualify as a security. In addition to this, he brought up the fact that Ripple did not register the cryptocurrency as a security as it was being marketed to institutional purchasers. Now, according to the most recent update, the Securities and Exchange Commission and Ripple will discuss the potential penalties that could be imposed for violating Section 5 of the 1933 Securities Act. Pay attention to important dates. Key dates have been established for the SEC versus Ripple case. Ripple is required to provide a response by April 12, 2024, while the SEC is required to provide a response by April 19, 2024. The CSE is required to propose its strategy by March 13, 2024. Judge Torres will decide the penalty for violations of securities law after these filings have been submitted, and a decision is anticipated to be made during the summer. After the conclusion of the lawsuit, both Ripple and the SEC will have the opportunity to file the following are the upcoming significant dates in the SEC Ripple case. The deadline for the Securities and Exchange Commission to submit its remedy-related brief is on March 13, 2024. The date of April 12, 2024 is the deadline for Ripple to submit its opposition to the remedy-related brief submitted by the CC. The deadline for the Securities and Exchange Commission, an interlocutory appeal against the programmatic sales verdict, was submitted by the Securities and Exchange Commission 2nd August. However, the court denied the SEC's request in October, delaying any appeal until the conclusion of the case.